Court Judge Harold Rothwax laid out his proposals for reforming the criminal justice system in his book Guilty: The Collapse of Criminal Justice. Of paramount importance to Rothwax is the exclusionary rule, which disqualifies any evidence the court deems part of an illegal arrest.
I think these exclusionary rules not only allow seriously guilty and often violent people to go free without good reason, but they also change the whole nature of the process. We're focused on what we ought to keep out of evidence rather than what we ought to allow into evidence. I've tried to argue that one way to simplify the law of search and seizure, which, as I've indicated, even the U.S. Supreme Court has conceded is intolerably confusing, would be to say that no evidence should ever be excluded where a police officer acts with objective reasonableness and subjective good faith.
The fact that about 1/3 of the people arrested for violent crime are on probation, parole, or pretrial release adds another dimension to the judge's frustration with the workings of the current system. According to Rothwax, revolving door justice has become a reality nationwide.
It is for you, the jury, to determine whether such intent existed in this case?
We don't have truth in sentencing. That's one of the problems. So a person may be sentenced to 5 to 15 years. And that means he's eligible for parole after he has served the 5-year time, sometimes even earlier than that.
The majority of states in 1997 often allowed convicted violent criminals to go free after serving a fraction of their sentences. Rothwax does credit New York as a leader in a group of states that requires serious offenders to serve over 80% of their sentences. Even so, the judge continues to criticize the logic of a system he is part of, but wants to improve.
This is insane. All it is a mass of technicalities and complexities that defy our ability to reasonably, fairly, proficiently prosecute people accused of crime.